Let's call the case of the people versus Sidney Lear.
Good morning, Your Honor. Craig Tappan, Special Assistant Attorney General for the people.
And good morning.
Ashley Moulton, Assistant Public Defender, appearing on behalf of Ms. Lear.
Your name?
Sidney Lear.
We are requesting a brief adjournment. I just found out recently that we do have discovery. I have not been able to review it or review it with Ms. Lear.
All right, you want the 26th or the 2nd?
Can we do the second?
Probable cause conference without objection will be adjourned January 2nd, 2025, 9 a.m.
May I briefly address bond?
Go ahead.
Thank you. Ms. Lear, we have received a potential offer from the prosecutor or from the Attorney General, which includes paying a portion of her arrears. Ms. Lear lives in Indiana, and in order for her to get the funds to do that, she will need to be out. So we're requesting that she is released on a personal bond in lieu of any monetary bond, if she could get a GPS tether, if the court is concerned.
I don't know what you're telling me, because the statute would require that the bond be set at the 25% minimum unless I have good cause, and I'm not hearing anything that amounts to good cause to change that.
Okay, she's unable to accumulate the funds while she's in custody. So that is my request at this time.
Okay, how did she come into custody? Because she resides in Indiana?
Yes, she was in custody in Indiana, and they brought her over here. She was sentenced to probation on December 1st, and they brought her.
So in essence, an extradition.
I'm sorry?
In essence, an extradition?
Yes.
I don't need a response. Motion for bond reductions denied. Bond will continue.
Thank you, Your Honor.
Thank you. Sorry to wake you up. No, go ahead.
I apologize.
Good morning, Mayor. Please, Honorable Court. James Johnson, on behalf of Mr. Brown, is both cases, Your Honor.
And what are we doing today?
Your Honor, we're asking for a preliminary examination on both cases, and I'd like to address my client's bond.
All right. Is all discovery complete?
Yes, sir, Your Honor.
If the people have their witnesses available on the 2nd?
We'll do our best, Your Honor.
Your Honor, the scheduled to be in the East Lansing and Lansing District Courts on the 2nd. Is it possible I can have a different day?
Yes. You can have the 7th.
9 a.m.?
Will that work? The 7th?
Yes, Your Honor.
Okay.
The matters that I have on the 7th not going to go.
Would the people have their witnesses available the 7th?
Continue to do our best. Thank you.
All right. Preliminary examination in person will be set January 7th, 2025, 9 a.m. That is before Judge Perry in both cases. Okay, yes, and that's the bond.
Your Honor, currently, as to both cases, my client does not have a bond. We're asking the court for a $30,000 cash assurity, 10% bond as to both cases. My client is not a flight risk. He does not have a passport, does not have a car, he does not drive. He is joined in the courtroom by friends of the family and family, which includes his mother and sister. We do not believe that he is a danger to the community at large. He has no prior criminal history that I am aware of. We do acknowledge that the charges are serious. The court can address that through bond conditions. There are no minors or minor children that he needs to be around. He can go to his mother's home and not be around any minor children. He has numerous people to make sure he gets to and from court. I've been in constant contact with his mother, his sister, and family members who are all here to support them. They even brought letters in case I needed to do a more formal bond motion. So we'd ask the court to consider allowing him to do post a $30,000 cash surety bond as to both cases.
Response.
Sir, it's my understanding that bond has been denied.
Yes.
Yes, and Your Honor, I would request that the court continue that stance. Obviously, for MCR 6.106, that's allowable. Judge, it's my best understanding, although I did not write the warrants in this case, that this pertains to sexual abuse of 2 are charged, 2 minors, but there are 4 that are involved. They're aged 4, 5, 6, and 7. They have all been interviewed. They all give various accounts of this defendant sexually assaulting truly all various ones of those children.
Let me make sure I understand what you're saying.
I'm not saying.
There are 4 children that are involved,
Yes,
but as of this point, only 2 of the, whatever the incidents are regarding, only 2 of the children have been charged.
2 are charged victims. That's correct.
Got it.
There is information from their interviews that lead me to believe that after a preliminary exam, it feels likely that there would be additional charges involving the same children already listed and quite possibly the 2 other children. These children talk more readily about seeing the defendant sexually assault one of their sibs rather than themselves.
Understood. Okay.
So, Judge, I would not be surprised if there were additional charges following a preliminary exam. I would indicate to the court that something that has not been charged but was disclosed in one of the interviews involved a gun at the children and threatening them. Obviously, counsel's correct. He's facing significant prison time. These are 25-year bandits. And when and if additional charges are levied, if they also involve additional CSC first, those would be discretionary consecutive, as obviously the court's aware. So we're talking significant exposure here. We're talking a year's worth of sexual assault on young children. I would ask the court to maintain its current bond ruling, which is to be denied just for the safety of the community.
Anything else, Scott?
Your Honor, there was extensive investigation here. No firearm was ever recovered from my client. The court will take the credibility of the children and inconsistent statements at the preliminary examination. However, again, all this can be addressed through no contact orders, house arrest, tether. He is not a flight risk. He is presumed to be innocent. And at this time, we do believe that the court has to find under that court rule that he is either a flight risk or through clear and convincing evidence, he's a danger to the community. I do not believe that there is clear and convincing evidence that he's a danger to the community with bond conditions that would include no contact orders with anyone the court may deem vulnerable at this point, Your Honor. So we'd ask the court to set the monetary bond with protectionary bond provisions, Your Honor.
The court does believe, and the court has reviewed the bond form that was filed by the people, that the court would consider the defendant to be a danger to the community as well, these children as well as any others. And while the court could certainly issue that condition, given the circumstances as the court understands them, that would not prohibit the defendant. I mean, it would be sort of an after fact that if we were to get there, and I don't think that that risk should be taken. I think that the magistrate followed the statute regarding denying a bond. The court doesn't see a reason to change that. Motion for bond reduction is denied. Bond will continue as denied. Thank you.
Thank you, Your Honor.
Court shall reduce the assistant public defender. Can I ask Mr. Rainey? How are you?
Going pretty good.
This your case?
You said Kyle Rainey?
Yeah,
This mine then, yes.
it is.
Well,
Okay, go ahead.
today then.
Yeah, that's fine.
Thank you. We're trying to get an offer on this file that Mr. Rainey would be happy with. We've not yet been able to negotiate that with the people. I'd have to negotiation and try to get the offer that
Can you
my
get that
client,
done by the second. You want the name?
the second should be fine, Judge.
Probable cause conference, January
Can
2nd,
I
2025.
say anything?
Hey,
Hey,
90.
Judge, can we I want to try to come to some kind of agreement today. I've already done 6 months on this case. You know what I mean? I came from one jail, got PR'd. They came and picked me up. I did my time over there and I only got a 3 month charge over there. They said they would release me earlier to a probation center. I didn't get to do that because you guys had a hold on me. I sat in there, then they came and picked me up after I got done with my 6 months, brought me here, and I've already sat for a month and have been adjourned twice now.
Okay,
I've never
I don't-
never been in any kind of drug charges.
sir, hold on before you go on. I don't know anything about that. It would be a bit hard for a resolution to happen today.
I did a
My
by
understanding
mail.
at the last hearing, they were attempting to try to get mitigation information over to the prosecutor. If they got that over to the prosecutor, prosecutors are gonna take that into account and trying to formulate some deal.
Because technically, it's
I
my
don't-
first drug cards via 7411. You know what I mean? I've never been in on any drug charges. I do have charges for like a CCW.
Sir, what do you want me to do?
I want to try to get this taken care of. I got a family at home that I'm trying to take care of. Or at least be able to get a PR so I could take care of my son myself. I've been locked up almost 7 months now. I got 3 kids at home. I got a dog that's about dying. I got a property that I take care of. I run a business. I just want to try to get some kind of leeway so I can take care of the stuff that I have to as a man. I don't have just family out there that can be just taking care of my properties, taking care of my job. I was a business owner. I went through a divorce and made some mistakes. I'm not trying to pay for it for the rest of my life. I'm going to lose everything.
Would you please take that, Judge, as a bond request on behalf of my client?
Any response from the people regarding,
Your Honor, in June of 2024, the defendant failed to appear and a bench warrant was issued. It appears that he was picked up on that in late November 20th, 2020.
so what happened with that? Let's stop there.
Sir, I left here, got picked up from Hillsdale County. They picked me up. I've been in jail ever since and then got brought here. I
Do
didn't. skip out
do
on
we
court.
have a showing that, you know what? Chill,
Yep,
chill.
I understand.
Sorry, Judge. I did discuss this with my client. He did suggest that he was in Hillsdale County when that.
Here's what I'll do. Let me do this,
Yes, Judge.
because you got to teach him how he addresses a court.
Yes,
I
Judge.
First of
apologize.
all, no, you're trying to force your way to do stuff. And I'm just going to tell you, first of all, were gone for a very long time from this court when I had it, and we didn't hear from you. So you might want to check how you're operating with me, because I don't have to do anything on this case today.
I understand, sir.
So what I'm going to do is I'm going to pass it, take him back. Mr. Feaster, I'll give you an opportunity to talk with him, look at and see whether you can verify what information he's giving the court, so the court can get his bucket.
Thank you, Judge.
Thank you. Court recalls the case, People versus Kyle Rainey.
Ready again, Judge. Court shall feature Assistant Public Defender appearing on behalf of Mr. Kyle Rainey. Mr. Rainey, please state your name again for the record.
Kyle Rainey. Hey, I apologize for my actions, the way I acted earlier. Just a little, frustrated.
Thank you, Judge. So if we may revisit the bond that. Mr.
Yes,
Rainey-
go ahead.
Thank you, Judge. So I did have a chance to go do some research on what Mr. Rainey was arguing. It does appear that he was granted a personal bond here back on June 6th, and he was then transferred to Hillsdale. He was in Hillsdale custody until November 20th. He entered a plea on that file in Hillsdale on September the 9th. His sentence there was 6 months, which is how we got to that November 20th date. He was then transferred back to Washington County because he had missed the court date here and received a bench warrant while he was in Hillsdale County Jail. And so now he's been here for another month, which is the total of the 7 months. But he was talking about, to confirm that I did have my office call Hillsdale County Jail, and they did verify that was the Deputy Jimenez at the county
That
jail.
he was there
Yes.
during the time that he was got it.
Yes, Judge.
Okay.
And so he's hoping the court will consider a release. He wants to resolve this matter, whether that be with a potential misdemeanor or 7411, but he's not running from this case. But at this time, Ms. Londy's still considering some options in terms of a potential plea resolution, is my understanding. And so we're not ready to resolve it quite yet. We're just hoping you might consider bond.
And that's correct, Your Honor. It's my understanding that at the time that the defendant was in Washington County Jail and then eventually went to Hillsdale, he had a hold from Hillsdale for a carry concealed weapon case.
And that's what he ultimately pled to. And that's the,
And that's what the time period was.
that's when he served the 6 months for that, and now he's on 2 years probation to Hillsdale County.
Yes. So I don't have an issue adjourning it, seeing if we can work something out. The concern of the people to resolve today is that there was that other felony that just happened and has now been pled to. So we want to dot our i's and cross our t's for how we'll resolve this case.
Got it. Okay, let me do this then. I'm gonna adjourn this hearing out to January 9th, 2025. At 9 a.m. Grant the defendant $25,000 personal recognizance bond, but he must be placed on a GPS location tracker prior to his release.
Thank you so much, Judge.
And does the board know we're doing testing in the interim, or is it working on just let him?
Did he have testing in place before? Tell you what, yeah, let's do that. I'll order testing one time per week, random.
Very much, Judge.
And see, sometimes, sir, if you just talk to your attorney and close your mouth, that was done in far less time than it took you to go on your little ramble tirade. Thank you. Have a good holiday. What? Court calls the case. People